All the angels held their breath as heaven put on human clothes. Rang the news, God did not forget His promise that was sent from the prophet's soul. The answer came in a secret birth, truth and justice began mine. The hope and the peace on earth rested in the hands of a newborn child. Hey, hey, from God in the highest, heaven made a way in a manger. From God in the highest, love was born through a simple virgin girl. It took a child to save the world. Yeah, yeah. For the ones who were lost again, every child of Adam's fall. Emmanuel was the precious name of the small boy who would grow and would touch his heart. Whoa. Out in the night, heaven made a way in a manger. Out in the highest, love was born through a simple virgin girl. A child to save the world. Out in the highest, heaven made a way in a manger. Out in the highest, love was born through a simple virgin girl. A child to save the world. So let the kings and the nations bow to the baby so divine. As we lift up our voices now, praises to the Savior of all mankind. Wow! Out in the highest, heaven made a way in a manger. Out in the highest, love was born through a simple virgin girl. Took a child to save the world. Out in the highest, heaven made a way in a manger. Out in the highest, love was born through a simple virgin girl. Took a child to save the world. The world that gave His only Son. Took a child to save the world, yeah. God so loved. You believe that gave His only Son. He came to seek the lost like you and I. Yeah. Came to seek, save, lead us back to Him. God so loved the world. God so loved the world that He gave His only Son. If you will believe in Him, you will have. You will believe in Him, eternal life you find. Good child.
Greetings, 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 greetings. I'm King Clifford Jefferson, Senator Godfrey the Fifth Kind of Grand Jew, son of folk, ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we know as the King of Peace. It is August the 20th, 2025, which is equivalent to the birth year 2975, I greet you in the name of my Queen Sister Galveston from the House of Galveston. I greet you in the name of Archbishop Bell from the House of Belmont. I greet you in the name of all officers on staff, members, heirs, inheritors, and all those who are trying to get understanding of what it is that we are called to do. This lesson is called Demise. Rex Nunquam Moritur. The king never dies, according to the statutes. What statute is that? New Jersey Revised Statute 46:3-2. Once again, Demise. Rex Nunquam Moritur. The king never dies. New Jersey Revised Statute 46:3-2. With that, let's get started. This marvelous lecture. I'm not going to hold the phone. Once again, like, share, subscribe. I love this free and common soakage. It's welcome. The Third Temple Church of England, or $ Clifford Jefferson L, which are the recipients, which is appreciated. I also want to give honor to our organization, the Third Temple English Church of England, which is the seat of our government. I can say that, just in case those are not aware of it. All those who are inquiring about what it is that we do, and check us out at the Third Temple English Church of England. Third Temple English Church of England. Our website. Those who have not been there, please go check us out. It's pretty much a detailed, informative, formal introduction about who we are and what it is that we do here at the Third Temple English Church of England, under the auspices of our Christ, King Edgar the Peaceful, which I am the reincarnation of, and my day of return in regards to the right of redemption, which is 2975, which is equivalent to the spring year 2025. Okay? For all those who have not gone to the website, please come check us out. All members, all subscribers, all heirs, welcome to the Third Temple English Church of England. Hear ye, hear ye, hear ye. Welcome to the Third Temple Church of England. We as English heirs are ordained by blood to bring the truth to the world that's been living in darkness as we come forth with the law and history of our forefathers and foremothers, instituted since time immemorial, written in the English Magna Carta of 1215 and codified in the Statute of Westminster of 1275. Through diligent genealogy research, we have uncovered our true identity and heritage, proving that we are the legitimate heirs and descendants from the Kingdom of England, now called Great Britain, now misnomer as United Kingdom. It is also important to note that our genealogy does not show any ancestry originating from Africa. Our mission is clear and urgent. It is to restore the rights, property, laws, life, legacy, peerage, custom, religion, value system, etc. of the Kingdom of England through the English crown and the English church, now known as the Third Temple English Church of England. We are committed to upholding our rights guaranteed under that Magna Carta we instituted under the Statute of Westminster of 1275. Through the Third Temple English Church, we are reviving the English Benedictine reform and the intellectual movement whose foundation goes back to our forebearer, King Edgar, our Christ, the Peaceful, and even further to his descendants, King Alfred the Great. King Alfred incorporated the Ten Commandments, the Mosaic Code, and the Christian codes of ethics into what we now know as the common law of England. We urgently call upon the international community, as well as the national community, domestic and non-domestic communities for support and solidarity. The descendants of the Kingdom of England, pardon self, the descendants of the Kingdom of England and Great Britain are living in today in what we now know as the United States, unaware of their true heritage and rightful nationality. They are facing a state of emergency, suffering from numerous atrocities and injustices without their voice being heard. We have endured significant economic disadvantages and a severe lack of essential resources crucial for our survival. Our community is plagued by insufficient access to nutritious foods, polluted water, and contaminated air. We are being harshly marginalized on our own land, leading many of us to what is now called homelessness. Your assistance is urgent to help us reclaim what is rightfully ours. Stand with us to restore justice and the dignity to those who have been wronged for far too long. Your support can make a difference in restoring the heritage and right of these rightful heirs. Please help us in this urgent cause. Thank you for your compassion and solidarity. My Archbishop of the Third Timothy Church of England, Archbishop Belmont from the House of Belmont. Thank you, Archbishop, for that beautiful royal decree. We also want to give honor to our authority. Also, if there are any questions, please post them in the chat line. Once again, like, share, and subscribe. We want to give honor to our authority, okay? We want to give honor to our authority. That which gives us the ability to do what it is that we say we have the right to do, okay? Very important, all right? So we have a website as well as a YouTube channel that's very informative, which falls under the authority of our certificate of incorporation. And modern, and that's the modern term for it, is usually called a charter. Okay, it's called a charter. Very important. And charters are originate from grants. Okay, charters originate from grants. Very important. If you're doing business for profit or nonprofit, you must have a certificate of incorporation. Okay, so we're not just doing this because we feel like doing it. We're doing it because it's an obligation. It's authorized because it's based upon operation of law of the estate that was passed down by our grantor. Okay? Very important that you realize the authority we have and our certificate of corporation. You understand, first of all, let's go a little further. It ain't like we just created this document. It's actually filed at the county recorder's office. Okay? The county record, not a quarter record, the county record, county government. Okay? This instrument, this template or front cover sheet is only for official business. So if you are claimed to be doing business, whether for nonprofit or for profit, and that you have authority that originated from a grant or under authority otherwise other than a grant, which means it will be de facto versus de jure. Okay, you must have a certificate of corporation. If you don't have that, 9 times out of 10, you're operating unlawfully. You don't have any official capacity to do what it is that you say you have the right to do. Okay? So we are, in fact, a religious society. And I'll be brief with that because we don't want to show everything. So when you go to the YouTube channel or our website, it's backed. Book and page number. Okay? It's backed. These are articles in the corporation. It's a contract between the members, i.e. subjects, i.e. citizens, who make up that corporation. Does not include anybody else. Okay? This must be first understood. We have a corporate domicile. We have a place of business. So no matter where the subjects or citizens go, they have a place of business that they can petition in regards to any violation of their rights that protected through their articles of corporation under the state laws that brought that entity to its existence, which usually derived from a sovereign grant. In this case, ours derived from a sovereign grant because it was the sovereign who granted it. That, in case in point, would be what? The corporation. So everyone hold that thought. The undersigned, each with the capacity to contract, hereby execute acknowledges the certificate of corporation for the purpose of forming what? A religious nonprofit in accordance with the state law where the entity came alive. Corporate domicile of the entity that came alive, that will be the Third English Church of England, i.e., the incorporation of the new, what we call, reformation of the English church. All right, just as King Edward did it in the 10th century, we're redoing it in the 21st century. Okay, very important. This is our corporate address, Perth Amboy, New Jersey, Providence, New Jersey, under the Kingdom of England. All right, under the Kingdom of England. We know the crown is indefinite. So, of course, we had to personify or incorporate or incarnate what the crown represents. Okay? Article 2 explains that. We can see Chisholm versus Georgia for a common law example. Okay? Based upon their review of corporations. The corporation sold, according to law, not according to anybody's wannabe understanding, is a legal entity consisting of a single sole incorporated office occupied by one sole natural person. This structure allows often religious corporations or commonwealth governments. So religious government or commonwealth government, which you now call republic government, are under the Article 4, Section 4 of the United States Constitution, a republic form of government is in fact a government of the crown. To pass without interruption from one office holder to the next, give a position legal continuity with subsequent office holders having identical powers and possessions to their predecessors. This is in fact called demise. Okay? This is called demise, brothers and sisters. Article 3. A means for orderly transfer of ecclesiastical property serving to keep the title within the denomination or religious society, in order to keep the religious property from being treated as the estate of the vicar of the church. The property was titled to the office of the corporation soul. A corporation soul, the crown, is the legal embodiment of the executive, legislative, and judicial governance in the monarchy of each Commonwealth rim, which you call a republic. Okay? Same thing. When you call the Commonwealth a republic, it's a result of out of office. The king is not in office, so therefore it's under what we call an interregnum. When according to the statute, there is no interregnum. All right, as a result of what we call the demise. This represents the demise. Prior to our incorporation, there was no demise of the crown. Okay? So it's not just the king's obligation, but it's your obligation as members of our corporation, i.e., body of politics, okay, nonprofit, charity. It's the member's obligation. I'll stop here. If you're not a member, you're not obligated. Article 4, members' purposes. According to the Magna Carta, Clause 1, the liberties of each of the English Church, now called the Third Temple English Church of England. First, that we have granted to God, and by this present charter have confirmed for us and our posterities, our heirs in perpetuity, not in violation of the laws governing perpetuity, but in line or in accordance with the laws in regards to perpetuity, that the English Church, now called the Third Temple English Church of England, shall in fact be free. It shall have its rights undiminished. We call that not unsuppressed. Okay? Unsuppressed. Okay? In criminal law, it's called suppression of evidence or suppression of law. It is liberties unimpaired. As English king, heirs and successors, it's the duty and allegiance to restore the peerage of English, the life of the English, and that's only based upon the history of the English Anglo-Saxon, who were in fact Berber English people, as well as the English church, our customs, our laws, traditions, religious belief, back to time immemorial, which would be the time of 1199, which would be Richard I. Here in America, which is still England, you just call it America. Commemorate our saints, martyrs, and the past kings and queens, restore the mysteries of King Edgar the Peaceful, known as our Jesus Christ. Okay? So this is what we're obligated to do based upon our certificate of incorporation. Okay? Filed for the county record. So this is our authority, this is our obligation based upon the language, the Habean clause for heirs and successors. Okay? Let's call it Habean clause. Okay? Very important you to understand that. So the state, the county, the municipality is already aware that office has in fact been found. Through what? Our certificate of incorporation. So this is prophecy. This is prophecy. Talking about the resurrection of Jesus or the incarnation of Jesus or the personification of Jesus. This is what they're talking about. The personification of King Edgar, the only king the only king in Middle Ages that whose whole reign was peaceful. Prior to that, there was conflict, war, disease, darkness, etc. I come to restore that. Okay? As the incarnation, as the personification, through the incorporation, through our certificate of incorporation of those past kings. Okay? Very important. It's qualified by the common law of England. Leeds versus Harrison. It's the Supreme Court of New Jersey. Lee versus Harrison. You need to write that down. 1952. Lee versus Harrison. Okay? It says corporate powers have their origin in the sovereign grant. So let's take a visual look of the conveyance, the demise. Okay, conveyance means the demise. Take a good look at that. If you're heirs, that would mean you're the grantees, inheriting what the grantor conveyed to you through the process of what we call library of season. Okay? Whether they were ruling on that side of the so-called landmass, which was separated between a body of water, you call that littoral rights or riparian rights, all right? Nonetheless, the grantor granted to the grantees, okay? By operation of law. If there is no operation of law for the conveyance of the grant from the grant to the grantee, then it automatically, by operation of law, it sheets back to the grantor, okay? Whether you're talking about land, whether you're talking about houses, whether you're talking about cars, whether you're talking about money, that will be, in fact, gold and silver, not paper notes, okay? Nonetheless, it still goes back to the grantee. But as a result of you forgetting this understanding or lack this understanding, this is what's happening. Okay? It's called demise. It's all falling into the demise. Okay? It all falls under what they call the demise. Reading Archbishop Alma from Alabama, glad you're able to join me today, or at least moderate. Okay? So we are in this position as a result of the suppression of who we are. And the only way that can be is a result of the suppression of the law. In criminal law, it's called suppression of evidence. Okay? Suppression of law means suppression of evidence, suppression of property law. Okay? They didn't abolish it, they just suppressed it. It's still alive and well. Okay? It's still alive and well. Let's go back to Leeds versus Harrison. Corporate powers, we're talking about corporations, we're talking about the powers of the corporations through the certificate of corporation. Okay? All right? Wherever state you incorporate, your certificate of corporations, within the instrument, your powers be expanded or limited, nonetheless, you have the authority to act within that power. Okay? So corporate powers have their origin or started in a sovereign grant. Okay? Now they're not given by a sovereign grant. It's just an enactment of some statute by act of legislation by de facto officers who hold the position. Nonetheless, there must be an office holding. Whether it's de facto, whether it's the jure, someone must in fact be in office. So corporate powers have their origin in a sovereign grant, usually. Generally, they are derived from the articles, listen, of incorporation or certificate of incorporation and the laws of the state under which the corporate body came into being. So under the certificate of incorporation or your articles of incorporation and your charter, that along with the laws of that state in which that corporate body, that nonprofit or profit corporation came into being. A corporation has those powers which are implicit in the charter. So a corporate charter or incorporation, articles of incorporation or certificate of incorporation are in fact synonymous. A corporation has those powers which are implicit in the charter as well as those which are expressed. Authority now reasonably within that corporate grant are excluded. but whatever may be fairly deemed an incident of power expressly confirmed by the charter is within the grant unless expressly prohibited. Okay? Can we at least understand how important it is to understand what makes up your charter? Okay? How far or what limitations your charters of incorporation are derived from. Because if it was derived from the state statute, then it's limited by those who created the state statute. Okay? They are your creator. Very important. Let's get a little bit more qualification on that. All right? And Chisholm versus Georgia. Common law. I'm going to take you by the hand. There could be no mistakes. Chisholm versus Georgia, United States Supreme Court, 1793. Okay? In regards to the concept of a corporation, whether you're talking about non-for-profit or for-profit, all right? Whether you're talking about non-for-profit or for-profit, you're talking about a corporation, okay? The only law concerning corporation to which, according to this case, can conceive the least reference is to that which falls under the common law of England on the subject in regards to what? Corporations. I need not repeat the observation I made in respect to the operation of law in this country here. All right? The word corporation, in the largest sense, has a more extensive meaning than people generally are aware. Anybody in politics, sole or aggregate, whether its power be restricted or transcended, is in a sense, in fact, a corporation. This is what you're reading, brothers and sisters. You're seeing prophecy come alive. Okay? The king, accordingly, in England, is called a corporation. By very respectful authors, is Parliament itself. In this extensive sense, not only each state singly, but even the United States may without impropriety be termed a corporation. So I have therefore, in contradistinction to the large and indefinite, used the term subordinate. A subordinate corporation, meaning to refer to such only alone capable of the slightest applicable application for the purpose of the objection, whose creation and whose powers are limited by law. What law might that be? The statute. Okay? The statute. I'm going to prove it in a second. The difference between such corporations and the several states in the Union, we're talking about colonies, brothers and sisters, in the Union, as relative to the general government overall, are very obvious in the following particulars. First, a corporation is a mere creature of the king or of parliament, very rarely of the latter, most usually of the former only. It owed its existence, its name, its laws, except such laws that are necessarily incident to all corporations, merely as such, to the authority which created, and they're talking about state statutes again, not that law created by the king by way of a sovereign grant, because it said in Lee versus Harrison, corporate powers derive their authority from the sovereign grant to their certificate of incorporation and the state where the entity came alive or came into existence. Okay? This is called operation of law. So a state does not owe its origin to the government of the United States, and the highest or in any of its branches. It was in existence before it came into being. Okay? Very important. So whether sole or aggregate, okay? Whether sole or aggregate, it is in fact a body of politics in reference to a corporation. Okay? Our certificate of incorporation, as incorporated, was in fact a corporation sold, filed for the county record. As you can see, our website and the YouTube channel is geared towards the mechanical work that all three platforms are obligated to do. Okay? Very important, because of operation of law. Let's look at this operation of law as it is in effect. Sole or aggregate, the king and parliament, as well as the state singly or the United States in general, as a corporation, that being subordinate to the king who creates the corporation. Okay? Under the common law. Let's see the statute that reflects that. Title 46, governing property law. This represents the demise of the crown. This represents the demise of the crown, because the demise means the transfer of property. The word demise means the transfer of property. So I'm giving you the prophetic instrument that was prophesied once office was founded by the king through our certificate of corporation under 16:1-28, right stated on the charge of Great Britain, saved from repeal, which was an act to incorporate trustees of religious societies for property held in corporations and place thereof. Okay? That is the law. Certain tenures and holdings turn into free and common soakage. The tenures of honors, manors, lands, tenements, or of hereditaments, or of an estate of an inheritance, at the common law, held either of the King of England or any other person or body politic or corporate at any time before July 4th, 1776. Okay? Before what? Anytime before July 4th, 1776. The King of England or person or body politics. This is called the demise. Okay? This is called the demise. Let's look at that. Because this lecture is called Demise. Rex Nunquam Moritur. The king never dies. Apparently, he ain't dead. He ain't in office, but he ain't dead. Okay? If he's dead, then it falls under what we call the statutes of mortmain, because there's an interregnum. There is no king in office. Prior to our incorporation, through our certificate of incorporation, there was an interregnum. There was no demise. But through our certificate of incorporation under 46:3-2, the transfer or the conveyance by office of an escheatment has now taken place. Okay? Has now taken place. Because it says King of England. So where is this King of England that they're talking about that was here before July 4th, 1776? Okay? And every year they enact this statute as if the King of England is here. He's not here as a result of him not taking office, but there is an office for the king, the body of politics. Because without the charter, no other state can have a charter to operate. Okay? We're going to examine that. Let's look at it. State of New Jersey. Let's look at the state of New Jersey real quick. The state of New Jersey incorporated under the law of the state of New Jersey via a statute. But it wasn't a sovereign grant, though, because Lee versus Harrison says that All corporate powers derive their authority from a sovereign grant through their certificate of incorporation and the state under the state laws where the entity came into existence. Okay? So as you can see, we came through 16:1-28, right? Cities under charge of Great Britain, as well as in regards to that property under 46:2, as regards to the founding of office, which you see in our certificate of corporation, domicile at what? 360 Lee Avenue, apartment 103. Okay? Perth Amboy, New Jersey. Province, New Jersey, in the Kingdom of England. Very important because that is our corporate domicile. New Jersey and their seat of government and their corporate domicile is governed by this statute, 52:1-1. And it says, Trenton is the county of Mercer and shall be the seat of the government of this state. All sessions of the legislature should be held at Trenton or on a temporary basis for ceremonial or commemorative purposes, or notwithstanding the public law by reason of an emergency or other exigencies at such other locations in the state, or shall be designated by the legislature by concurrent resolution. Okay? So as you can see, when New Jersey came into existence, it wasn't based upon no sovereign grant. It was based upon a state law, 52:1-1. Nonetheless, it was not a sovereign grant. Because as you can see, there is no sovereign authority listed in the government under the state of New Jersey because it's a provisional government. It's temporary. How do we know it? Let's see. How do we know this? New Jersey Provincial Council. The revised statute match up exactly with what we're reading here on Wikipedia concerning His Majesty's Council for the province of New Jersey. Okay? Matches up perfectly. His Majesty's Council for the province of New Jersey was the upper house of New Jersey legislature and colonial rule until it was replaced by New Jersey Legislative Council under New Jersey's Constitution of 1776. Look in the box, New Jersey Provincial Council, leadership, the structure, and as you can see, the local faction, length of term is indefinite, authority is the Crown of England, the alternative seat of where the government sat was either Perth Amboy, where we are now, or either Burlington, New Jersey, okay? Two alternative seats are where the government will be functioning, okay? Either Perth Amboy or Burlington. Now it sits in Perth Amboy as a result of our certificate of incorporation, which brought our corporate nonprofit called the Third Supreme Church of England back alive again. Alive and resurrected by their king. All right? Very important that you understand this. Rex Nunquam Moritur, the king never dies. We know that because the statute just said the king never dies. If he's dead, why are they still mentioning him here? Mention him in New Jersey 5 Statute 46:3-2. Why are they still mentioning the king? Why? Before July 1776. Why are they still mentioning the king? This is a statute. This is operation of law. Okay? So if you receive a grant to start a corporation based upon operation of law, it must come from the King of England and not based upon an enactment of a statute that gave the corporation the right to exist under the statute, which was an unlawful statute because it was in violation of the common law, which clearly states, based upon operational law, govern the charters, which governs the conveyance by the grantor to the grantee property, which clearly says here, it must be held either by the King of England or any other person acting as the King of England on behalf of the body of politics, which is based upon the corporate charter. Okay? The corporate charter. We must understand this language. Okay? Let's go to demise. Rex Nunquam Moritur. Rex Nunquam Moritur, the Latin phrase translated to the king never dies. This phrase means that even if the monarch dies, the institution of kingship continues to exist. This is often symbolized by the succession of heirs or the continuity of the monarchy itself. Additionally, it can represent the idea that the king's influence can persist long after the death, leaving a lasting legacy. Okay? Apparently, that legacy is still alive, according to New Jersey by statute 46.3-2. This legacy is still alive. Rex Nunquam Moritur translated that the king never dies. This phrase means that even if the monarch physically dies, meaning his natural body, the office is still intact by the successor king. If the successor king does not come into that tenure or office by way of inquisition of office, inquest of office, founding of office, then it's what we call an interregnum. Okay? That the institution of kingship continues to exist. Once again, the phrase means that even if the monarch dies, the institution, the body politics, the government, or the office continues to exist. I don't know how more simple to make this to the people. All right? It's called the demise. We see it was right here in New Jersey in 1776. Right here, under the law, New Jersey by statute, the operation of law says this office is still here. Okay? This office is still here. How can that be? If the office is still here. Who is that King of England? Prior to 1702, all the way up to 1770 to 2025, where is this king that they keep talking about based upon operation of law, especially in regards to property, land, and anything else that sits on the land from the grantor, which will be the king. And the only person that would be the beneficiary to that grant would be the heirs, not the ones who are the trustees, but the heirs. All right? Very important, but you understand that. We'll look up the word, the crown, demise. Demise. Let's read it from Law Dictionary, second edition, Valentine. Demise. A lease of a term for years, a conveyance of a fee, a life estate, or an estate for years. I'm not going to read all the other mumbo jumbo, the case law. You can pull up the actual dictionary yourself to do all that. A word which may imply a covenant of title in a lease for years. This is the conveyance from a grantor to a grantee. If it's not a grantee, to a tenant-in-chief. If it's not a tenant-in-chief, then it's to a friendly enemy, alien, okay? It's a friendly alien. Very important to remember those terms. While it is true that the terms demise and let are usually supplied to leases and conveyances of real estate, yet they both contain the idea of a grant. And when the parties have used them as operative words, applied to the transfer of rights and contract for terms of years, the transaction amounts to an assignment. Okay, you see Atlantic versus North Carolina, Atlantic versus North Carolina. So tender is the law of supposing even a possibility of the king's death, that his natural dissolution is generally called his demise. Demisio regis vel coronet, the demise of the king or crown. Once again, the demise of the king or the crown. An expression which signifies merely a transfer of what? Property. Okay? A transfer of property. So let's read the demise of the crown. The transfer of the kingdom to a dead king's successor. When we say the demise of the crown, we mean only that in consequence of the disunion of the king's natural body from his body of politics, the kingdom is transferred or demise to his successor. And so the royal dignity remains what? Perpetual. Brothers and sisters, perpetual. That's a law dictionary. It's the Black Law Dictionary. This is what we see in New Jersey Revised Statute 46:3-2. It remains perpetual. Demise. Black Law Dictionary, 5th edition. Demise. Now, a conveyance of an estate or to another for life, for years, or at will, most commonly for years. This is called a defeasible title. Not indefeasible, but defeasible title. Originally a postmortem grant, commonly a lease or conveyance for the term of years, sometimes applied to a conveyance in fee for life for the years. Demise is synonymous with lease or let. The use of term in a lease imports a conveyance for quiet enjoyment. Okay? So it's a life tenant, defeasible tenant, or fee simple. Okay? The word is also used as synonymous with the deceased or death. In England, it's especially employed to denote to the death of a sovereign. Okay? Death of a sovereign. Demise of the crown. The natural dissolution of the kings and generally so-called, and especially which signified merely a transfer of property by demise of the crown. We mean only that in consequence of the disunion of the king's natural physical material body from his body politics, the kingdom is transferred or demise to his successor, and so the royal dignity remains what? Perpetual. Okay? Perpetual. That's right here in New Jersey Revised Statute 46:3-2. Right here. Live and well. Everyone read that while I go warm my coffee up. Read that, and if you like, if you agree with what was just brought forth based upon operation of law, not based upon belief, not based upon somebody's history lesson, not based upon somebody's narrative, not based upon a court dissent, but based upon what the law says. Can I get a thumbs up in the chat line? Greetings, Brother Thomas from the House of Thomas. Glad you were able to join us today. So demise means a transfer or lease of property. It represents a grant. Okay? This represents, in fact, a grant. That brings me to this statute. Now, New Jersey didn't get it from a grant. They just got it. They just became an entity, a body of politics, incorporation, by way of a statute created by an enactment of legislation. Though it was an unlawful enactment of legislation, nonetheless, the office must be there for a de facto officer or the jure officer to even sit there. Okay? For any government to exist, there must be in office, whether it's a jure or de facto. Without that, there will be chaos. There will be disorder. Okay? What we have now is controlled chaos versus chaos that's not controlled. Okay? Very important to understand what's going on. All gifts and grants. All right? Talking about grants. All gifts or conveyances made prior to and after July 4th, 1776. This is the Declaration of Independence, brothers and sisters. Before and after any grant, any gift, or any conveyances that were made by the king according to New Jersey by statute 46:3-2, which clearly says all tenures of honors, manors, lands, tenements, or hereditaments, or estates of inheritance at the common law, which was a grant, okay, by the King of England or any other king acting as a king or in the office of the king, which controls the body politic, which is de facto corporation, because king creates corporation. Parliament, but usually is of the latter and usually of the former. Before July 4th, 1776, okay, that authority had to be under the authority of a grant from a sovereign, because as Lee versus Harrison clearly stated, corporate powers have their origin in what? A sovereign grant. A sovereign grant. So when you go back to this picture here, you better be think about what you have right now in your possession. You really better think about right now what you have in your possession and under the auspices or under the presumption that you think is yours. Whether it's houses, whether it's cars, whether it's money, okay? Do you actually have a right to it? Because ownership and possession are two different things. Ownership and possession are two different things. Ownership and possession, two different. You must understand that. Hold that thought. Okay. The corporate powers have their origin in sovereign grant, generally derived from the Articles of Incorporation and the laws of the state under which the corporate body came into being. So the body politic corporate body came into being under the state law, okay? And New Jersey came into being under the state law that will be the state statute that was not based upon the sovereign grant because of what the state statute says, which we're reading it. All tenures, all manors, all lands, and all inheritance of hereditaments before July 4th, 1776. Okay? It's right there in the statute. The tenures and honors, manors, lands, tenements, or hereditaments, or of the estates of inheritance at the common law held either of the King of England or any other person or body politic or corporate at any time before July 4th, 1776, are declared to be free income mensokis. All right. Then we have 46-3-6. That's 46-3-2. This is 46-3-6. All gifts and grants or conveyances made prior to and after July 4th, 1776, other than the state of inheritance by a letter patent, that would be a charter, that would in fact be a grant, under the great share of the state or any other manner by the state, by the legislators thereof, or by the commissioner or agents of forfeited estates, or by other lawful and competent authority under the state, shall and remain allodial and not feudal, and shall forever be and continue to be free and pure allodium, only forever discharge of all feudal tenures and the interest thereof, and any other services whatsoever. Okay? Whatsoever. So this is telling you that all the corporate powers that arrived from the sovereign grant based upon the statutes in New Jersey were dissolved. Okay? They were dissolved. Why? Because the land now remains allodial, because there are no feudal tenures, and as a result of that, the land automatically cheats back to what? The king, under what we call the demise. Okay? The demise. That's the demise. Demise, an Anglo-Norman legal term to send away for the transfer of an estate, especially by lease. It has an operative effect in a lease, implying a covenant for quiet enjoyment. Once again, for quiet enjoyment. The phrase demise of the crown is used in English law to signify the immediate transfer of the sovereignty with all its attributes and prerogatives to the successor without an interregnum, in accordance with the maxim, the crown never dies. Rex Nunquam Moritur. Okay? I know this might be offensive to a lot of you as a result of this information being brought to light, but nonetheless, Rex Nunquam Moritur, the crown never dies. This is in the statute, and proven by via statute that the crown never dies. The phrase demise of the crown is used in English law to signify the immediate transfer of the sovereignty within all its attributes and prerogatives to the successor without an interregnum, and according with the maxim, the crown never dies. Why is this important? All right. We already know that the crown was here back in 1702. All right. The crown was here in 1702, called His Majesty's Provincial Council. Right here. And the length of term was indefinite. We already see that. No one disputes that fact. All right? No one disputes that fact. But if the crown is already here in 1702, all right, then that only brings me here. The Demise Crown Act of 1702. The Demise Crown Act of 1702. And legislative enactment, okay, but not by the Parliament of Great Britain, not by the Parliament of the United Kingdom, but for the Parliament of England, even when there was an interregnum of a de jure king. Queen Anne was a de facto king, but nonetheless, office must be found for a government to exist. Okay? So even under the office of a de facto officer sitting under the offices of the King of England or Queen of England, they maintain that the office will be perpetual. It will be perpetual. The Demise of the Crown Act of 1702 was an act from who? The Parliament of England. It abolished the rule that all legal proceedings automatically ended upon the death of a minor. Did you hear that? It was an act of the Parliament of England, even though she wasn't the English king. It abolished the rule that all legal proceedings automatically ended upon the death of a minor. That's why New Jersey Revised Statute 46:3-2 is there. That's why it's there, brothers and sisters. That's why it's there. Long title. An act for expanding a clause in the act made at the Parliament begun in the holding of Westminsters and the 20th of the November of the 17th year of the reign of the sovereign Lord King William III, entitled An Act for the Better Security of His Majesty's Royal Person and Government. Did you hear that? The securing of His Majesty's Royal Person and Government. This is called the demise of the Crown as a result of the demise of the Crown Act of 1702 in regards to Rex Nunquam Moritur. The king never dies. Okay? The king never dies. We must understand that if you're going to understand this lesson. Okay? Let's see how when it was transferred. When did the king's government get transferred to a successor? Okay? A successor king by way of primogeniture. All right? So any king could have became a successor based upon primogeniture, but it was suppressed about the law. It was suppressed within the law about the crown's prerogative. Who suppressed it? Let's look at it. So when we look at the colonial history and the governments of the 13 colonies, which we have right here, talked about this already, but we have to go over it. The government of the 13 British American, the 13, so the government of the 13 colonies of British America developed in the 17th and 18th century under the influence of the British Constitution. It didn't say English America, it said British America. It didn't say the English Constitution, it said the British Constitution. That would be the Bill of Rights. The British monarch issued colonial charters that established either royal colonies, proprietary colonies, or corporate colonies. Understanding corporate powers derive their authority from a sovereign branch, used that's within the state, where the certificate of incorporation was incorporated under the state laws where the entity came to existence. Whether it was a corporate colony, a proprietary, which is a joint Scott colony, or a royal colony. Okay? Whatever it was, you had to have a charter. British monarchy issued colonial charters that established either royal colonies, proprietary colonies, or corporate colonies. In every colony, a governor led the executive branch, and the legislative branch was divided into two houses, the governing council and the representative assembly. Men who met property qualification elected the assembly. In royal colonies, the British government appointed the governor and the council. And proprietary colonies, the proprietors appointed the governors and his council, and corporate colonies, voters elected these officials. These are called charter colonies or for-profit charter companies, meaning that they were for profit versus non-for-profit. Very important to understand that. The American Revolution from 1763 to 1783 was a dispute over the British Parliament rights to enact domestic legislation for the American colonies. The British government position was that Parliament authority was unlimited, while the American position was that the colonial legislature was co-equal with Parliament and outside of its jurisdiction. As the revolution progressed, the colonial government were replaced by temporary provincial Congress, and ultimately by state constitution establishing a Republican government, which is seen in New Jersey by Statute 52:1-1, a temporary government. Okay? We've seen it right there in modern day statute in 2025. All right? This brought on what we call the imperial government established by the British Constitution. After the Glorious Revolution of 1688, Great Britain was governed as a constitutional monarchy with sovereignty residing in the king and parliament. Parliament was bicameral legislature. Aristocrats inherited seats in the House of Lords, while the gentry and merchants controlled and elected the House of Commons. The British monarch possessed executive authority, but he relied on the cabinet ministers of the Privy Council to actually run the actual government. Okay, so this is a de facto government instituted at this particular time under the de facto authority, under the de facto crown, under the British government that was established in 1707 with the union of the crown in 1706. Okay, very important. By the start of the American Revolution, the 13 colonies, British colonies, had developed political system featuring a governor exercising executive power and a bicameral legislature made up of a council and a assembly. The system was modeled on the British Constitution, as we read earlier, with the governor corresponding to the monarch, the council to the House of Lords, and the assembly to the House of Commons. The American colonies were proud of their status as British subjects. Once again, the American colonies were proud of their political status as British subjects and claimed the same rights as Englishmen as their counterpart in the mother country. Did you hear that? So the American colonists said they were proud of their status as British subjects, but they wanted the rights as English subjects, as Englishmen, as their counterparts in their mother country. This is where the okie doke came in, y'all. This is where the okie doke came in. Let's read. The crown. The 13 colonies were all founded with royal authorization, and authority continued to flow from the monarch as colonial government exercised authority in the king's name. That means king's out of office, or if the king ain't in office, then he's out of office. That means that it's acting under its officers, i.e., the king's trustees. They were part of what the British America, they were part of what was then British America and the Kingdom of Great Britain, which was originated in 1707 through the Union of the Crown. A colony precise relationship to the Crown, which we know in 1702 was right here in New Jersey. It was called His Majesty's government in what we call Perth Amboy. Not over in what they call the territory known as Great Britain or United Kingdom, but right here in Perth Amboy in 1702. And the authority of that crown was indefinite. Okay? They're the one who gave out the charter to all corporations who incorporated under the laws of the crown at that particular time. You now call them state statutes. A colony precise relationship to the crown, depending on whether it was a corporate colony, proprietary colony, or royal colony as defined in its colonial charter. Whereas royal colonies belonged to the crown, proprietary and corporate colonies were granted by the crown for private or to private interests. Okay? Word for word. Okay? No exaggeration. Let's go further. You can read the rest of this at your own time. We're just going to go down where the meat at because the whole argument is about the demise of the crown. We know Queen Anne passed the Demise Crown Act in 1702, based upon the demise of the crown, based upon what the crown represents, which we clearly represent. Okay? The office is still intact via New Jersey Statute 46:3-2. King of England, body politic, person, or corporate, at any time before July 4th, 1776. Okay? Very important. Provincial government, right? Control over corporate colonies were granted to joint stock companies, which were proprietary companies, under the authority of the Lord Proprietor, such as Virginia Company, Virginia, Massachusetts, Connecticut, and Rhode Island, were all founded as corporate colonies under corporate charters granted by who? The grantor, which will be the King of England. Whether the king sitting under the King of England and under the crown was de facto, nonetheless, office was in fact found. New England's corporate colonies were virtually independent of royal authority and operated as republics or commonwealths, which were property owners elected by the governor and under his legislators who he elected based upon their laws that they enacted under laws of the proprietor, which we know was only there for non-profit reasons. For profit reasons. Proprietary colonies were owned and governed by individuals known as proprietors, i.e., profit reasons. To attract settlers, however, proprietors agreed to share power with property owners. Maryland, South Carolina, North Carolina, New York, New Jersey, Pennsylvania were founded as proprietary colonies. There you have it, all wrapped up in one, brothers and sisters. Read on. So the governor and the governor council were all running the government of the crown, i.e., the king, without the king being in office. Okay? This has always been the case. All right? As a result of the overthrow, the suppression of evidence, the suppression of the law, the suppression of the history of the English people. Okay? Very important to comprehend as I go through these templates. Going to the colonial history, all right? Up to the demise. We already defined what the word demise means, okay? We already understand what the word, true intent of the word demise means. We ain't gonna use it loosely, especially under the context of what it is that we're talking about, the crown and the crown's property, okay? So therefore, when we use the word demise, we're going to use it in a reference in law in regards to property transfer or property lease, okay, of an estate that was supposed to be belonging to the heirs, okay, all right, that were supposed to belong to the heirs. Before the American Revolution, attempts to create a unified government for the 13 colonies were unsuccessful. Multiple plans for a union were proposed by the Albany Congress in 1754. One of these plans proposed by Benjamin Franklin was the Albany Plan. All right, there were a couple of them as well, which all ended with the Connecticut Compromise. Okay, the demise. The American Revolution, the colonial government ceased to function effectively as royal governors, paroled and dissolved the assembly. By 1773, committees of correspondence were governing towns and counties, and nearly all the colonies had established provincial congresses, which were legislative assemblies acting outside of what? The royal authority. It's the Treasons Act, brothers and sisters. It was then, and it still is today. All right? Right here. Demise. Talking about the demise. Okay, all the way up from the starting or the founding of the colonies. And we know the colonies were founded based upon royal colonies, proprietary colonies, or just chartered colonies, which, as we see in Lee versus Harris, is all colonial power or colonial authority, derived authority from the sovereign grant. Now, usually the certificate of incorporation under the state laws where the entity came into existence or from the grant. Okay, because like they said, they're usually derived from a sovereign grant, and if it's derived from a sovereign grant, the grant must be from the sovereign. Okay, very important. It says in May 1776, this will be May 15th, under John Adams, what we call enactment, the Congress called for the creation of new governments where no government sufficient to the exigencies of their affairs had been hitherto established, and that the exercise of every kind of authority under the crown should be totally suppressed. I repeat, we just read that the Majesty's crown was here from 1702, and before 1702, it was indefinite. We understand the Crown Act of 1702 was to maintain the integrity of the person and the Crown's government. And we see that in lieu of that enactment, legislated by the Parliament of England, all right, as well as what the Crown stands for, they still took it upon themselves to suppress information. They didn't dissolve the authority of the Crown or the demise of the Crown, they just suppressed it, okay? It said in May 1776, the Continental Congress called for the creation of a new government where no government sufficient to the extendency of their affairs had been hitherto established, and that the exercise of every kind of authority under the Crown should be totally suppressed. The Declaration of Independence in July further encourages the state to form new governments, and most states had adopted new constitutions by the end of 1776 because of the Revolutionary War. New York and Georgia did not complete constitution until 1777. And we just read in 1702 that His Majesty's government under the authority of the Crown, going back to 1702, was indefinite, okay? That authority was suppressed by the colonies who made up the 13 colonies, all right, as a result of treasonous act, brothers and sisters, okay? We see the New Jersey revised statute said that the demise was undertaken. We see that the demise of the Crown has taken place. The transfer of the king's property to what? The next successor. That has happened as a result of our incorporation. Let's see. Martin versus Waddell. 1842 case. Nazi Supreme Court. If the king held such land as trustees for the common benefit of all his subjects, and inalienable as private property, I am unable to discover on what grounds the state of New Jersey can hold the lands discharged of such trust and can assume to dispose of it to private and exclusive use of individuals. Okay? This is Martin versus Waddell. How can the state of New Jersey automatically dispose of property under adverse possession? Let's get an example of what I'm talking about. How was New Jersey able to do this when Martin versus Waddell said they were not? How did this happen? When land is streets, it goes back to the Crown as a result of there being no heirs, i.e. grantees, okay? But if the heirs are not there and if the Crown is not there, then the power of treatment goes back to the state of New Jersey under what they call a bona vacatina, abandoned property. They don't know who the hell it is, or do they? Yes, they know. They just suppressed it. Brothers and sisters, they suppressed it and took it for their own public use under the eminent domain power of the state of New Jersey, and then enacted or created through the state statute government agencies, not an authority of a grant by the sovereign, by an act of law, de facto law, okay? And then when that law came effective, it allowed for what we call adverse possession by individuals through the process of what we call subinfeudation, okay? The alienating of property, whether it was voluntary or involuntary. Nonetheless, it's still a process of adverse possession. It's not through lottery of season as conveyed by lottery of law, operation of law, okay? We must understand how important this lesson is, even though you might not want to watch it, and that's apparent because I only got 2 viewers. But that's okay, though. That is okay. Get it? If the king held such land as trustees for the common benefit of all his subjects, and inalienable, meaning that it cannot be subinfeudated. Printed Petoris, which under the state statute clearly says that you cannot alienate land that's intel, which belongs to what? Heirs. There's state statutes right now that qualify that, which we go through before the ending of this lesson. Okay? So if the king held such land as trustee for the common benefit of all his subjects, and subjutation as private property, parts of, and inalienable as private property, I'm unable to discover on what ground the state of New Jersey can hold that the land discharged of such trust as trustee and can assume or presume to dispose of it to a private exclusive use of an individual. If it was a trust estate in the king for the benefit of his subject, and upon the revolutionary government of New Jersey became the trustee in the place of the king, meaning king not being in office, it's right there. Now we see New Jersey by statute right here, since the king was supposed to be in office, right? The king was supposed to be in office. This ain't case law or common law. This is the legislative statute and the intent of the statute, word for word. The King of England or some other person sitting as the King of England, whether you de facto or jure, you're responsible for the perpetuity of that body of politics, which is a corporation. That was in existence before July 4th, 1776. So if the king ain't there, then the body of politics must be there, and that body of politics, according to Martin versus Waddell, must be what? The state of New Jersey. Okay? Because it's talking about what? The state of New Jersey. If everyone agrees with that statement, can I get a thumbs up in the chat line? If everyone agrees with that statement, can I get a thumbs up in the chat line? Martin versus Waddell. The king held such land as trustees for the common benefit of all his subjects and inalienable as private property. I am unable to discover on what ground the state of New Jersey can hold the lands under bona vacatia and discharge of such trust and can assume to dispose of it to the private and exclusive use of an individual. If it was a trust estate and a king for the benefit of his subject, and upon revolutionary, the government of New Jersey became the trustees and place of the king, and the trust devolved upon such government, and the land became as inalienable in the government of New Jersey as in the king's hand. You hear that? As in the king's hands. And as in the king's, so as in the hands of the king, and the state must be bound to hold all such lands subject to the trust, which as contended embraces a common right of fishery and waters and the dredging for orchards in the land covered by the waters. And if this be so, there certainly can be no power in the state without a breach of trust to deprive the citizens of New Jersey of such common right and convert these orchard grounds to a private and exclusive use of individuals. So he's telling you, in this case, that the land, the water, and everything that pertains to the land and the waters belong to the citizens and the citizens alone. And that will make them subjects of the king. All right? Because the state of New Jersey are trustees for what? The crown. Okay? There are trustees for the crown. This is what the case law says. Okay? And if the trustees are not acting, then guess what? It will be the king will be the trustee, as we see right here. It will be the king who will be the trustee. And we see United States versus Sing Tuk or Kingdom. We know who the subjects or citizens are. It says it right here. Further clarifying our argument. Must an American citizen seek to return to his native land and be compelled to bring with him 2 witnesses to provide the place of his birth, or else be denied his right to return and all opportunity of establishing his citizenship in the courts of his country, No such rule is enforced against an American citizen of Anglo-Saxon descent if this be as claim a government of laws and not men. Once again, no such rule is enforced against an American citizen of Anglo-Saxon descent, proving that he is in fact a national, okay, a citizen or a subject of America. Because America is what? England. Well, let's talk. You know what's funny about this? I've shown legislative statutory law to support our argument. I've shown common law, case law to support our argument. I've shown the history to support our argument. I've shown that they're even saying what we're saying to support our argument. Nonetheless, no one's paying attention. Nonetheless, no one's paying attention. The American citizens are Anglo-Saxon descent. No one can make up the Anglo-Saxon like those of the Anglo-Saxon descendants. Okay? Very important. Why? Let's go into it. Here's the case. Jones versus Freeman. I'm going to pull this case up. Jones versus Freeman. Article 4, Section 4. A republic form of government was based upon Rex Nunquam Moritur. The king never dies. Okay? This is the Oklahoma Supreme Court case in 1904. Okay? 1904. Part of the opposite dictum that is not mal is that the president but the jure legislator consists of the jure members in sufficient numbers, both in the House of Representatives and the Senate, that no doubt can be cast upon the validity of acts hereto passed by the legislature. Until promulgation of the majority's opinion, there was no determination that the legislative districts, House and Senate, were invalid. And whereas there may be a king, though an usurper upon the throne, nevertheless, there must be a throne upon which the king may sit. Okay? I repeat, this is going to fly right over brothers and sisters' head. All in lieu of New Jersey Revised Statute 46:3-2. King of England. Okay? Office being found, inquest of office, traverse of office, inquisition of office, or finding of office, all right? This results from demise. And we know that when the demise transfer of from the crown to the successor back in 1702, the office was there, but there was no king there. Okay, so it always remained an interregnum. Okay, so I meant that as Martin versus Waddell said, that the trustees were acting in place of the king. Those trustees will be the body of politics called New Jersey, not the body of politics incorporated under New Jersey by statute 52:1-1. Not them. We ain't talking about this right here, because they're temporary. We were talking about the one that was there prior to creation of this body of politics, i.e. corporation, because this was not from a sovereign grant. The government of Trenton did not derive their authority from the sovereign grant of the crown. We know all corporate powers derive their authority from a sovereign grant, and that's through their certificate of incorporation, which usually derived in the state where the entity came into existence, where Trenton and the government, or the body of politics of the government of Trenton as an entity, by way of the legislative enactment via the statute, came or existed ceremonial and commemorative on a temporary basis. How many of you can understand that? Okay? How many of you can understand that? All right? So these officers, even though they hold an office, are de facto. Not de jure, de facto, because they did not derive their authority to be a government by sovereign grant, i.e. the proprietaries, i.e. the charter colonies, i.e. or the royal colonies. All their authorities were granted by a sovereign grant, because the king was there to grant the land by way of lottery of season and not adverse possession, which is the play, which is what we're subject today, due to today. All right, let's get it. Jones versus Freeman. So as we see, until promulgation of the majority of opinion, there was no determination that the legislative districts, the House and the Senate, were invalid. Whereas there may be a king throwing an usurper upon the throne, nevertheless, there must be a throne upon which the king may sit. This is based upon Blackstone commentaries. Okay? If there is no throne or a king sitting upon the throne, that means any king or any successor claiming to be a king will be a de facto king, which means you will be illegitimate. Okay? How do we know that? Let's see what Blackstone says about it. In 1461, on the occasion of Edward IV's Plantagenet descendant from the House of Lancaster, which was that branch of the Plantagenet king, which descended from the Angevin kings, which descended from the Plantagenet king. In 1461, Edward IV, Parliament declared the previous Henry of Lancasters usurpers. The House Henry VIII from the House of Lancasters, Elizabeth I from the House of Lancasters, the House of Stuarts from the House of Stuarts, and all their claimants are de facto kings because they got their start from the House of Lancasters. So, I mean, everyone who descended as kings of England from then to the present were in fact de facto. Okay? We're reading common law case law. In 1461, on the occasion of Edward IV, Parliament declared that the previous Henry of Lancaster usurpers, but to avoid great public mischief, also declared them kings de facto, and persons were punished in that reign for treason to Henry IV, not in aid of the lawful claimant of the crown, i.e., this can only be done by finding of office. Okay? Very important. This court recently held that there could be no de facto office where there is no office to fill. There can be no de facto office where there is no office to fill. We must understand that. There must be an office for someone to fill that office, whether it's de facto or de jure. Why? Because there will be chaos. There will be chaos. Okay? We need a standard. They said in this case, the standard was the Anglo-Saxon law under Rex Nunquam Moritur. The king never dies. That was the standard. Okay, let's see it for ourselves. Come on, hating on this lesson. This bill was supplemented by the rule promulgated by the Supreme Court of the United States in Norton versus Shelby County, Tennessee. While acts of a de facto incumbent of an office lawfully created by law and existing are often held to be binding from reason of public policy, the acts of persons assuming to fill and perform the duties of an office which does not exist de jure can have no validity whatever in law. Did you hear that? Did you hear that? While acts of a de facto incumbent of an office lawfully created by a law, state statute, and existing are often held to be binding from the region of public policy, okay, the act, nonetheless, of that person is someone to fill and perform the duties of an office which does not exist de jure can have no validity whatever in law. Did you hear what they just said in Jones versus Freeman, a 1904 case? Did you hear what it just said? I hope you did. The doctor said the Missouri court presupposes an office which the law recognizes. Mere possession of a public office is insufficient to make an incumbent a de facto officer. Possession plus color of to title to office, if office actually exists, is sufficient. Did you hear that? Mere possession of a public office is insufficient to make incumbents a de facto officer. Possession plus color of title to office, if office actually exists, is sufficient enough. Okay? Nonetheless, it has no validity. It has no validity. Mr. Justice Field in Norton versus Shelby County Super resided from Supreme Court of the United States. He stated, but is it contended that an act creating the board was void? But it is contended that if the act creating the board, i.e. commissioners, trustees, whatever, was void, and the commissioners were not officers de jure, they were nevertheless officers de facto, and that the act of the board as to the de facto court are binding upon the county. This contention is met by the fact that there could be no officer either de facto or de jure if there is to be no office to be filled. As the act attempted to create the office never became a law, the office never came into existence. So in order to create a de facto office, there must be an office to put a de facto officer there. Okay? Very important we understand what's being said to us, especially dealing with the tenure of the king. Okay? The tenure of the king, as we see in New Jersey by statute 46.3-2, which makes every other officer, if they're not an officer of the king, in fact, de facto. Okay? De facto. Let's read it. The United States said an unconstitutional act is not a law. Once again, an unconstitutional act is not a law. It confers no right. It imposes no duty. It affords no protection. It creates no office. It is in legal contemplation and inoperative as though it has never been passed. An unconstitutional act is not a law. It confers no right. So if you're out there doing things contrary to what the Constitution said, it's not protected by the law. It has no effective force. Okay? It creates no office that of the force of the office that was created by the law that created the office. It is a legal contemplation and it's an operative as though it has never been passed. When the finding of a de jure tenure is found, the de facto will cease to be. Okay? Get it? This is a deep case right here. I can't go into the depth of it as a result of um, uh, what's being talked about today. I promise I will in future lessons. The old Court of Appeals under the Articles of Confederation denounced as unconstitutional the law that assigned circuit duty to the judges of that appellate tribunal. Judiciary, debate of Congress, and ancient British presidents, American Law Review, and in the Doomsday Book, it was recited. What power the king has, he has by law. The greatest inheritance that the king has is the law. For if there was no law, there would be no inheritance and consequently no king. Did you hear that, brothers and sisters? Let me just highlight that real quick. So in the Doomsday Book, it was decided what power the king has, he has by law. The great inheritance that the king has is the law. For if there was no law, there would be no inheritance and consequently no king. Did y'all hear that? Did you hear that? So if you claim to have an inheritance under the law, you must in fact have a king. Okay? The demise of the crown. It must be transferred from one king to the next. All right? If you claim to have an inheritance and you claim to get that inheritance by way of lottery of season. If you don't claim or you don't want it under the law, then you by right, you don't need a king. Because as the Doomsday Book stated, it was decided what power the king has, he has by the law. The greatest inheritance that the king has is the law, for if there was no law, there would be no inheritance and consequently no king. Okay? This is common law precedents, and we see that right in the legislative intent and New Jersey by Statute 46:3-2 in regard to inheritance. Let's look at it for ourselves again. It's right here in the statute. It's right here in the statute. Before they created their de facto government. Right here. Only fools stuck the truth. The tenure means a holding, possession, a grant, a gift of honors. So you have to be an honor to be able to possess a tenure from the king, whether they're a manor, a lands, a tenements, or of hereditaments, or in the state of inheritance at the common law held either by the King of England or any other person sitting as King of England in control of the body of politics, which is in fact a corporation soul. Okay? It is a corporation soul. The very thing you read in the common law is right there in the legislative intent. All right? Right there in the legislative intent. Jones versus Freeman. Everyone agree with that? Please give me a thumbs up in the chat line. If you agree with that clarity that I just brought to light, give me a thumbs up in the chat line. Right here. Give me one Sorry about that. It's a shame how many people are asleep. This is just a shame, right? Resurrection is real, what they call the rapture. Second Thessalonians, was it 2:15? One of those verses. The dead shall rise in Christ. Those who are alive should be awakened and should be caught up. And the twinkling of an eye, that's talking about a physical, a conscious awakening, right? Blessed for those who partake in that first resurrection, which the second resurrection have no sting. Okay? While the legal issue determined in Marbury versus Madison was neither intricate nor novel, and converse of the difficulty of the legal issue in the case at bar, and it had to do with the prerogatives that actually belong to the king, is not even comparable. The political issue is the same. It is whether the court would declare legislative acts void and adhere to the Constitution by decreeing and enforcing representation as constitutionally provided, or leave the right of suffrage to other agencies, as the former, the majority opinion, holds. Article 5 in Section 11 of the Constitution, the state was divided into 33 senatorial districts, 22 of them being given one senator each, and 11 being given two senators each. Two counties, Harmon and Cotton, have been created since the Constitution was adopted. However, listen, y'all, listen, very important. Being counted amongst the census. So I take my sweet time. However, the framers of the Constitution intended that the legislative apportionment contained therein should serve only until 1911. The constitutional apportionment was intended to be only temporary. Okay? So apportionment based upon the census at that time, or who can even be considered as candidates for the two houses, all right, was based upon the census enactment at that particular time, which we'll discuss further, all right, based upon the 1911 apportionment. We'll discuss that. Of course, the framers of the Constitution intended that the apportionment provided in the Constitution should be superseded decennially, but only by valid legislative acts adjusting representation in the House of Senate, as equitably as may be, and to this end, specifications of equality, compactness, and limitation on numbers of senators were detailed in their Constitution. And equally true, the framers of the Constitution made certain that there should be no hiatus in government, meaning confusion about that. It was well known to them that without valid provisions for an office, not even an usurper in office could, when challenged, lawfully remain to perform the function of government. Listen, it was well known to them that without a valid provision for an office, not even an usurper in office could, when challenged, finding an office, inquisition of office, traversal office, lawfully remain to perform the function of government that by unconstitutional function of government that by unconstitutionality and consequent invalidity of apportionment statutes or failure to enact them, there will be no valid provisions for or creation of the legislative office, with the result that there would and could be no future legislative department of government that without legislative departments of government. Oklahoma will fail as a government Republican in form, and that such a government was required by federal Constitution, Section 4, Article 4, and that the means was then provided to enforce the requirement. Once again, I repeat, based upon Jones versus Freeman, I repeat, Of course, the framers of the Constitution intended that the apportionment provided in the Constitution should be superseded decentrally, but only by valid legislative acts adjusted representation in the House and Senate as equally as may be, and to this end, specification of equality, compactness, and limitations on the numbers of senators were detailed in the Constitution. And equally true, the framers of the Constitution made certain that there should be no hiatus in government. It was well known to them that without valid provisions for an office, not even an usurper in office could, when challenged, lawfully remain to perform the function of government. That by unconstitutionality and consequent invalidity of apportionment statutes or failure to enact them, there would be no valid provisions for or creation of the legislative office, with the result that there would and could be no future legislative department of government. That without a legislative department of government, Oklahoma will fall as a government Republican form, and that such a government was required by federal Constitution, Section 4, Article 4, and that a means was there provided to enforce that requirement. What is this requirement, brothers and sisters? Let's read it. The United States shall guarantee to every state in the Union a republic form of government and shall protect each of them from invasion, meaning that the government must continue on from one office holder to the next office holder. If there is no office holder, nonetheless, the government still must function. Okay? So the United States guarantees under Article 4, Section 4 of the United States Constitution a commonwealth or republic form of government, which is a result of the kings not being in office. Okay? That's what you have now. Right, Brother Thomas, they failed to see. They failed to see. The United States guaranteed when there was no king in office, or when there was a king in office de facto, all right, that the form of government under the de facto office will be, as they said, under a republic and a commonwealth. When it was under the House of Stuart, it was under a commonwealth. It is under when it transferred from the House of Stuart to the colonies, now called state, is now called republic. Nonetheless, it's still the same. They failed to see that, like Brother Thomas from the House Thomas clearly pointed out. And that all probability, once again, the United States should guarantee to every state in this union a republic form of government and to protect each of them against invasion. And on application of the legislator or the executive, when the legislature cannot be convened against domestic violence. And that all probability, domestic violence as a result of chaos would ensue if a de jure or de facto legislator cannot be convened. Once again, that in all probability, they already know. And in all probability, concerning our domestic, i.e., the place where we're domiciled, that violence will occur, which results as a result of chaos when there's no de jure government. So if there's no de jure government, the government still got to function under the facto members to make it look de jure, but not under de jure laws that are in fact de facto. Okay? So in all probability, domestic violence as a result of chaos would ensue if a de jure or de facto legislative could not be convened. We're talking about two houses, the House and the Senate. So the standard was that Anglo-Saxon civilization afforded a rule of law. Y'all don't hear me. Y'all don't hear me. The Anglo-Saxon afforded a rule of law. Rex Nunquam Moritur. And to avoid such chaos and violence, the Constitution was construed to provide in Section 10, Article 5, in regards to Rex Nunquam Moritur, which means the king never dies. We see that right there in the revised statute, a continuance of the king's government based upon the legislation against all invasions against that government, protected by the legislation against domestic treason. Okay? Very important. Let's see it. That in all probability, they know the domestic violence as a result of chaos will ensure if a de jure or de facto legislature could not be convened. Anglo-Saxon civilization afforded the rule of law. Okay? What rule of law? The common law or the legislative law? The rule of law or the legislative law? If you're not using either or two, the former or the latter, then pretty much your state of affairs are in chaos. Okay? The House of Representatives, until otherwise provided by law, should consist of no more than 109 members, based upon their obligation as trustees as officers of the body of politics for the king if the king's not there. Okay? If the king's not there. That's actually what that's saying. Let's get a little bit more insight. Now we know United States versus King Do or Sing Do, that American citizens are the Anglo-Saxon citizen. There is no proof needed, okay, to establish that. Now we're talking about the standard, the rule of law, okay? The rule of law. Because they said that based upon the apportionment of the 1911, that the government of the United States was temporary, provisionary, just like the government before that enactment in 1776 was provisionary, okay? It says that the framers of the Constitution neither recognize that the apportionment in the Constitution contained should serve only until the year 1911, nor that the Constitutional apportionment was temporary. Let's go back up and let's backtrack a little bit. All right, let's backtrack a little bit. Here. Well, Article 5, Section 11. Under Article 5, Section 11 of the Constitution, it states that the state was divided into 33 senatorial districts, 22 of them being given one senator each, and 11 being given two senators. Two counties being Harmony and Cotton has been created since that Constitution was adopted. However, the framers of the Constitution intended that the legislative apportionment contained therein should serve only until 1911. The constitutional apportionment was intended to be only temporary. Okay? The article, the legislative intent said it was temporary, but they didn't take that to be true, based upon new provisions being provided for the dissolving or the divesting of the authority as established by Article 5, Section 11, based upon the new finding of office once we find out that the office now in tenure were in fact de facto versus de jure, because they said it must be an office, whether de jure and de facto. We know the rule of law was based upon the Anglo-Saxons, which we know was based upon the law of the king. We know that God makes the law and the law makes the king. So if you came to be a king and it's not authorized under the law, 9 out of 10, you're not a king. Okay? Let's get it. So they realized that the Constitution and provisions governing the Constitution and limitations based upon their articles of incorporation within the Constitution, which framed the authority based upon whether it was granted by the king or not, their limitations and their prohibition. Okay? Very important. So let's see that they didn't abide or adhere to the 1911 apportionment being temporary or provisionary. Why? Let's see. On Jones versus Freeman. Talking about office, those who hold office are the jure de facto. When the de jure officer is not found, then the officers who are de facto are have a lawful tenure as a result of public policy. Okay? But the policy that was public is now a lawful policy based upon the rule of law. Let me read this again. Once again, in the Doomsday Book, it was decided what power the king has, he has by the law. We see in Revised Statute 46:3-2 that the king has power in lieu of the inheritance as a result of law because 46 governs property. Okay? So it says the greatest inheritance that the king has is what? The law. So why you think I'm using the law to transfer the inheritance from me to you? It is my obligation. But if there was no law, there will be no inheritance, and consequently, there will be no king. Okay? If that makes sense to anybody out there in TV land, please give me a thumbs up in the chat line. Let's see why they did not adhere to the 1911 legislative enactment, Article 5, Section 11. Okay, let's see why. The framers of the Constitution neither recognized that the apportionment in the Constitution contained should serve only until the year 1911. It was supposed to be a temporary or provisionary charter that lasts up to 1911, but they never really was going to confide based upon that legislative intent, nor that constitutional apportionment was temporary. Some meaning must be attributed to each word, phrase, and sentence employed in the Constitution provision. Verba cum effectu exceptienda sunt. The Constitution provisions are to be construed as people adopted them understanding the meaning. What other meaning can be attributed to the phrase verba cum effectu exceptienda sunt, which means until otherwise provided by law. But when you say until otherwise provided by law, meaning that there is a law that already in place that prohibits what you have now enacted by an enactment of law. Okay? There's already a prohibition put in place based upon the exercise of law that is being exercised, which is in violation of the law as a result of the government, that's de facto, and the officers who are sitting in the government, that's de facto, which makes the laws of that government de facto. Okay, which means that they are in fact invalid. So it says the constitutional provisions are to be construed as to the people adopting them, understanding the meaning. Okay, so if you don't understand the interpretation I'm giving you, then the laws you're going by based upon the interpretation and meaning fit the script. Okay, but if you do understand based upon my comprehension of the law and my explanation of the law based upon what the law says, then you should not get the same meaning based upon the script that they're running on. All right, because it says until otherwise provided by law. So if there's a provision of law providing for the overturning of some law, then that means that law, it has more weight than that law that they're using at that point in time. Okay? Very important. So what other meaning can be attributed to the phrase until otherwise be provided by the law? And the phrase until apportionment is made by the legislator, except in the sense that if, as when the legislator enact valid legislative apportionment acts, that constitutional provisions upon the subject are superseded. Okay? So we're talking about an apportionment of law, okay, based upon some law that was enacted in 1911, okay, and they go off that enactment that was enacted in 1911 or any other date of an enactment law until shown otherwise that enactment of law and the exercise of the law and those who are exercising it are invalid based upon the office, okay, very important. You see, I go through this case. I don't play around. Thus, the framers of the Constitution of Oklahoma were of the Websterian view. Okay, whatever that is. Nothing is more essential to a free government than an independent judiciary to afford relief to a citizen in the event of governmental invasion or omission as to the inalienable rights of men. What rights are in question? The rights of Englishmen, because we know they were British subjects wanting the rights of Englishmen. Okay, so if they want the rights of Englishmen under the English government, which we proved the English government was here back in 1702, and we know that the Demise of the Crown Act of 1702 was an act for the perpetuity of the king's government, the king's officers, the king's laws, and the king's system. Okay? Nothing is more essential to that free government than an independent judiciary to afford relief to the citizen in the event of governmental invasion or omission as to the inalienable rights of men. Okay? Property and the life of every citizen may become subject to its judgment, and the protecting power is needed to strengthen government too. Not a contract is made except in reliance upon the court's ability to afford redress if it is violated. Men part with property upon the promise of their fellows, walk the streets by day and sleep in peace at night, and confident that the silent and unseen power of the judiciary is ready to protect that right. Okay? So that means that there's any violation in regards to your rights under the 4th, 5th, 6th, 7th Amendment and protection of right, securing person, property, and effects, the court system is there to render aid, my brothers and sisters, okay, based upon the office that were given to those who tenure that office, okay? The only question you need to ask yourself is it de facto or de jure? De jure. Because if it's de facto, that means you're going to get a de facto relief versus a de jure relief. And we know that the jure relief was based upon the rule of law that was administered based upon the Anglo-Saxon under Rex Nunquam Moritur. The king never dies. All right? The king never dies. Let's continue. These are what you call checks and balances. All right? Checks and balances. According to Justice Brandeis in Myers versus United States, it states we're established in our government in order that this should be a government of laws and not of men. Okay? In order to be a government of laws and not of men, we must hold to the standards of the Anglo-Saxons. How we know that? Because the Anglo-Saxons are the citizens who make up the United States. All right? How we know that? Let's go to United States versus King Do or Sing Do again to prove it. Right here. Must an American citizen seeking to return to his native land be compelled to bring with him two witnesses to prove the place of birth, or else be denied his right to return and all opportunity of establishing his citizenship in the court of his country? Question. No such rule is enforced against an American citizen of Anglo-Saxon descent, and if this be a claim, a government of laws and not men. So if this is the case, then this is not a government of men. I mean, this is a government of men who do not abide by the government that was established by the law, i.e. the lawgivers, and who were the ones who set the rule of law, the Anglo-Saxons, i.e. Rex Nunquam Moritur. The king never dies, okay? Right there. So we must regain our status as subjects or citizens of England, now identified as America, okay? This is a must. Going back to Jones versus Freeman. So the checks and balances were established in our government, this government being Anglo-Saxon. Hold on 1 second, brothers and sisters. Sorry about that. As we can see, the Anglo-Saxons are in fact the subjects or the citizens, okay, which we do not need to prove, okay, that this is in fact England. I didn't say that. The statute says it, and the case law says it, okay? They say, what else do they say in this case? Based upon a de jure finding of office, based upon the jure officers and their finding once it's questioned, okay? Once it's questioned. No one knows how to question them. This is what we call a core warranto, an order to show cause under what authority and do you act, okay? This is also called an order to show cause. It said to prevent abuses, the barons rested with King John at rudiment the various guarantees of the Great Charter and stipulated therein rights should not be so delayed or denied, and that the king should appoint justiciars, sheriffs, and bailiffs of such as know the law of the land and are disposed duly to observe it. Do you hear that, brothers and sisters? When you go to those courtrooms, you see those officers, are they acting de jure? No, they're acting de facto. Why? Because under the legislative intent, that was discretionary. It became discretionary until until what they stated, until the law provides otherwise. Okay? Until the law provides otherwise. The law already provides otherwise. Okay? It already has. You just don't know it. It also says, so too to prevent abuses, the Constitution provided for a judiciary to be manned by men as independent as the law of humanity would afford, in charge of supreme judicial agency with the duty of exercising a particular jurisdiction, and when warranted by the facts, afford relief to any citizen who sought a review of statutes. Hear that? Providing unequal and unjust legislative apportionment. Okay? Very important that we understand that, because I'm showing you all three. The king has shown you all three. The basics of the state constitution. I repeat. The basic of idea of a state constitution, in this case will be New Jersey, is popular representative of government. The officers being mere agents, not rulers of the people, one who where no man is so high as to be above the Constitution, or no one so low as to be beneath its protection. You hear that, brothers and sisters? This is how we're supposed to be talking. This is how we're supposed to be understanding. This is how we're supposed to be exercising our rights as citizens. Shall the illuminating prejudice of history ever be forgotten? Shall the landmarks of the fathers and the lighthouse planted upon the shores upon which other states have floundered be turned away? Question mark. Are the secrets of the old doomsday books of Anglo-Saxon to be read in vain? Question mark. Or as part of the administration of right and justice, should speedy and certain remedy be afforded for every wrong? Question mark. If that day shall ever come, when the disappointment and disgruntled suitors gather with the political demogius, that means a leader, to bid the judges to come down from the judgment seat to answer the excited multitudes for the mere error of judgment, and to plead to their mercy rather than to the justice under the law, the safeguards of the Constitution, and will be trampled underfoot. Once again, if the judges come down off their seat as a result of the demogious political leader and the multitudes bringing judgment against those who sit in those seats in lieu of violation of the law, it clearly said the safeguards of the Constitution would be trampled underfoot. This will cease to be government of laws and become a administration of the people, where the law is not the rule of life. And the state of Oklahoma, the hour of low 12 would have struck. No longer would the future be mentioned under the slogan, let the people rule, that ushered the statehood into a happiness existence. Officers chosen by a popular vote, points out. Officers chosen by a popular vote. By popular vote in lieu of a government from afar. If and when, as a result of our actions, this seems to be a government Republican in form, and our state again becomes subject to federal courts or part of the public domain, Section 4, Article 4, under the federal Constitution, we say Section 4, Article 4, that's what you should be, because the public domain is the king's domain. Private property, they cannot touch it. It might be well petitioned to return the Republic of Commonwealth to the Indians, such as the Cherokees, who under the laws of civilized tribes with bicameral legislative system dominated the House of Kings and Warriors and had government responsive to the needs of the red man. When you're going back to red man, you're going back to history involving Oklahoma. Oklahoma was part of the territory called the Caddoan, Mississippi, indigenous people there, which is a long history that I don't want to go into for the sake of today's class. But it's very important to understand that we rely on the Anglo-Saxon history, which set the standard for the rule of law and the jure government that we seek for due process of law. All right? Very important that we do that. Why is this the case? Let's see. Apportionment Act of 1911. All right? Because under the Apportionment Act of 1911, that the government and the government or the convention of the government was convened was supposed to be dissolved. Okay? But they stated under the provision based upon that phrase until provided by law. Okay? They extended their stay here. All right? So let's see the provision of the Apportionment Act of 1911. Let's see it. Very important. Previous apportionment. To give effect to the requirement of Article 1, Section 2, Clause 3 of the United States Constitution and Section 2 of the 14th Amendment, the United States representatives be apportioned to the states in proportion to their respective population, concurrent with past apportionment acts following each census. For it is based upon the census, brothers and sisters. It is based upon the census, right? In lieu of Article 1, Section 2, Clause 3, and Section 2 of the 14th Amendment. We're talking about Article 1, Section 2, and Clause 3, and we're talking about Section 2 of the 14th Amendment. We know the 14th Amendment has to do with what? The Citizenship Clause, okay? The Citizenship Clause for emancipated slaves, and not the Citizenship Clause of those dealing with the citizenship of the United States. Under Article 1, Section 2, Article 3, under the Naturalization Act of 1790. That's very important because this is where we're going next, all right? Once again, the provision and apportionment of the 1911, based upon the public law enactment and the statute at large, it says to give effect to the requirement of Article 1 that deals with the House and what they call the United States Constitution, and the Section 2 of the 14th Amendment, a United States representative and apportionment to the state in proportion to their respective population, okay, which is usually the note to the census, all right? Now, there was an Apportionment Act of 1911, and there was an Apportionment Act in 1792, based upon the census of 1790, okay? Very important. So in order to deal with the Apportionment Act of 1911, which was questioned in Jones versus Freeman in regards to the parameters set up by Section 5, Article 5, Section 10, pursuant to the Republic Form of Government Article 4, Section 4, which means either Republic or Commonwealth, which means whether they be de jure or de facto under the King of England, or which is de jure, or King of Scotland, which is de facto. Nonetheless, the office must be in existence. We already see in the legislative intent under New Jersey by Statute 46, colon 3-2, based upon the demise of the crown property that is based upon not the statutes created by the British Parliament or laws of the United Kingdom, but these were based upon the enactment of laws of the Kingdom of England and the English Parliament, okay? The demise of the crown enactment of 1702, okay? Which is still intact and is still in force in this present day. So the Apportionment Act of 1911 is rooted in the Apportionment Act of 1792. Let's look at that. All based upon the census at that particular time. We're talking about your representation. Who it is that you claim represents you, okay? Who is it that speaks on your behalf? The Apportionment Act of 1792, as quoted in the statute, was the first Apportionment Act passed by the United States Congress in April 10, 1792, signed into law by who? President George Washington, okay? What method did they use to come to that result? The Jefferson method, okay? Which is based upon the census. Let's look at that. Apportionment Act of 1911 depends upon the Apportionment Act of 1792, which is based upon the Jefferson method, which is called the Hunt method. Let's look at that real quick. The Hunt method, also called the Jefferson method or the greatest divisor method, is an apportionment method for allocating seats in Parliament among federal states. Did you hear that? Or in proportional representation among political parties. I repeat. The Hunt method, also called the Jefferson method or the greatest divisor method, is a apportionment method for allocating seats in Parliament among federal states or in proportional representation amongst political parties. I hope y'all understood what that means. Okay? So that goes back to the apportionment of 1911 and 1792, all based upon census of 1910 and 1790. Okay? Apportionment of 1911 was based upon the census of what? It was called the, make sure I know what I'm talking about. I think it all goes down to the census. Okay, so the census of 1910, the census of 1910, based upon the 1911 Apportionment Act of 1911, which is rooted in the Apportionment Act of 1792, which is based upon the census of 1790, which we're visit now. Let's go there. All still under the Constitution, Article 1, Section 2, uh, Article 1, Section 2, pursuant to the 14th Amendment. Okay? The 14th Amendment. All right? Very important. All right, let's get it. I don't know why it's up. I take my time and I'm slow as a door mouse, but hey, gotta be. I just stack 79. Here we go. Naturalization Act of 1790, or the Census Act of 1790. Okay? Naturalization Act of 1790 was a law of the United States Congress that set the first uniform rules for granting United States citizenship by naturalization. You hear that? Granting United States citizenship by naturalization. The law, naturalization to free white persons. Okay? To free white person. Now, this is the best part of today's class. The revelation you're about to receive now. All right? Now we see what Jones uh, 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 versus Freeman stated about the representation, okay, under the rule of law. If it's the jure, then it's based upon the Anglo-Saxon rule. If it's de facto, then it's any rule other than that. Okay? Let's just look at that real quick. See what the law says. Rule. Who are the lawgivers and who are the lawbreakers? Constantly go back and recover what we talked about. Very important. Have to. Because you go out one ear, come in one ear and right out the other. Okay? Oklahoma, it says that without a legislative department of government, Oklahoma, or any government for that matter, will fail as a government Republican in form, and that such a government was required by the federal Constitution, Section 4, Article 4, and that a means was therein provided to enforce the requirements. Okay? To enforce the requirement. The United States government should guarantee every state in the Union a republic form of government and should protect each of them against evasion and the application of the legislature or the executive when the legislature cannot be convened against domestic violence. That in all probability, domestic violence as a result of chaos will ensue if a de jure or de facto legislator could not be convened. Anglo-Saxon civilization afforded the rule of law. Rex Nunquam Moritur. That same law you see in New Jersey by statute in 2025 under the Jersey by statute 46-3-2. King of England, body politic, corporate, or person. Okay? If it's not that government that's still there today based upon the demise of the crown, protected by the Demise Crown Act of 1702, then guess what? It's a de facto government. It is a government of chaos based upon or the result of the representatives of the official office holders of those offices. Okay? Very, very, very important because we're going back to the Apportionment Act of 1911, which descended from the Apportionment Act of 1792, which were both based upon the census of 1910 and 1790. Which goes back to the Naturalization Act of 1790, which deals with free white person. Okay? Free white person. 1790, United States citizen, and United States Naturalization Act of 1790 both deals with free white persons who are naturalized citizens. Okay? Under Article 1, Section 2, Clause 3. Okay? And not based upon the second section of the 14th Amendment that deals with those representatives under Article 1, Section 2 that were operating under the body of politics, going back to Rex Nunquam Moritur. The king never died. They don't want to fill that office because they can't fill it. They don't meet the requirements. They must be of Anglo-Saxon descent. Okay? How we know that? If we look at the Naturalization Act of 1790, the Naturalization Act of 1790 was the law of the United States that set the first uniform rules for granting of United States citizenship by naturalization. So if you're a citizen of the states or the citizen of the United States, when the United States came into being, based upon the representation that was apportioned by the Apportionment Act of 1792 and 1911, guess what? You are a naturalized citizen. Okay? You are a naturalized citizen. You are, in fact, what they identify as free white person, but naturalized. Okay? Not a national. Naturalized and national are not synonymous terms. We must understand that. Okay? So why I bring that up? Because it has nothing to do with nationalization or a nation or a country. How we know it, just look at the intent of the Naturalization Act based upon the Census Act of 1790 and the representatives who was going to represent the citizens based upon the Citizen Act of 1790, based upon the Naturalization Act of 1790, as well as any enactment that was enacted based upon any Apportionment Act based upon the representation of the citizens that was then later based upon the Citizen Act of 1910. Okay? Nonetheless, they are all naturalized citizens. So to summarize the approach that must be taken in deciding whether a particular person applying for citizenship based upon the Naturalization Act of 1790 and the Census Act of 1790, okay, based upon the definition of a free white person within the meaning of the statute as interpreted by the Supreme Court, it is necessary to determine the first particular groups or racial subdivision to which individuals belong. Because as we read in Martin versus Waddell, that the state of New Jersey are trustees, and it will be unlawful as trustees to convey property that belongs to heirs to an individual that's not an heir. Okay? Very important. So it says that the Supreme Court, it is necessary to determine first a particular group or racial subdivision to which the individual, in fact, belongs. In practical effects, proof of this fact is a matter of genealogy. Okay? An individual who presents a aberration from the color of skin of the group of which he is a member, such as a light-skinned Chinese or Japanese or dark-skinned Anglo-Saxon, does not thereby acquire a different status under the act from any other member of its group based upon the classification or character as described in the Naturalization Act of 1790. Further testing must be done to prove, in fact, that they are, in fact, true members, the true members of that group based upon a genealogy test, a nationality test. Not a naturalization test, but a genealogy test. Of course, when an individual applying for citizenship has shown by the usual method of proving genealogy that he is, in fact, a member of that group, after the individual has traced himself into his group, now the second question, which the court must now answer, and you must answer even if you're not in the court of law, whether the member of that group as a whole or a white person, as Congress understood it in terms of the statutory or legislative enactment of 1790 when it was first enacted by the statute. In deciding the latter question, in regards to the Naturalization Act and citizenship status afforded by the Naturalization Act of 1790, based upon the representative afforded by the Apportionment Act of 1792, they clearly state here that after the individual has been traced into his group, the second question which the court must answer is whether the members of the group as a whole or a white person as Congress, i.e. the representatives based upon the Apportionment Act of 1792, understood it in the terms of the Citizenship Act of 1790 when it first enacted the statute, in which, deciding the latter question, the test is not how the group in question will be classified based upon I'll talk too fast. And question will be classified by ethnologists, who have made a study of their racial origin, but rather what group of people then living in 1790 were characteristics then existed which were intended by Congress to be classified as white person. Applying this principle to the court's finding, the petitioner is an Arab, and Arabs are not white person as intended by the Legislative Act in 1790, based upon the Census Act of 1790, apportioned by those representatives apportioned at that particular time by the Apportionment Act of 1792, and later on through the effects of law enacted. Okay? Very, very, very clear. There's no misinterpretation about what's being said today. So in closing, Fairfax versus Demise. An alien can take land by purchase, though not by descent. At the common law, or in other words, he cannot take it by an act of law, but he may by an act of a party. Okay? There is no distinction whether the purchaser be by grant or by devisee. In either case, the state vests in the alien not for its own benefit, but for the benefit of the state. Or in the language of the ancient law, he has the capacity to take but not to hold land, and that may be seized into the hands of the sovereign for one of office. Until lands are seized, the alien has complete dominion over them. He is a good tenant of a freehold and preside under what they call common recovery, which is changing intel estates and to fee simple. It may convey the same to the purchaser. It seems indeed to have been held that the alien cannot maintain a real action for the recovery of land, but it does not this follow that he may not defend it in the real action, his title of the land against all persons but the sovereign. In respect to these general rights and disabilities as to real property, there is no difference between an alien friend and alien enemy. Okay? So an alien may hold property, may convey property, may purchase property, but he may not do it by operation of law. It only can be done by adverse possession. Okay, that's very important. Adverse possession. That is the example as set forth by the real estate book as provided by New Jersey. Okay, right here. That's the only way land can be conveyed in any state is by adverse possession, which is open, notorious, continuous use of property that does not belong to them by what they call prescription of sovereignty. Okay? Versus lottery of season. Okay? Contrast to lottery of season, how it should be conveyed. Let's close out on that. We see that in Gouverneur and heirs versus what was it? Robertson. Same language. It states here, and I quote, that an alien can take by a deed and can hold until office found and must now be regarded as a positive rule of law so well established that the reason of the rule is little more than a subject for the antiquary. It is no doubt owes its present authority, if not its origin, to the regard to the peace of society and the desire to protect the individuals from arbitrary aggression. Hence, it is usually said that it has regards to the solemnity of lottery of season. Once again, it is usually said that it has regards to the solemnity of lottery of season, which ought not to be divested without some corresponding solemnity. Divested means what they call uh, um, uh, shouldn't be distinguished. What's the right word? Definition. Separated. Severed. Okay. Which ought not to be severed without some corresponding solemnity. Once again, hence, in regards to property owned by an alien, whether you're enemy, friendly alien, or enemy alien, if you got property, if you have not received it by lottery of season, then it's not in what we call solemnity. Okay? And anything contrary to solemnity is notwithstanding, brothers and sisters. It's notwithstanding. I didn't say that. The legislative intent has stated that. Let's go to the legislative intent. Lottery of season by solemnity. Okay? By solemnity. Right here. A proper form of conveyance. All under Title 46, colon 3-9. If you make property under the law, it must be by lottery of season. As stated in the case law, or some corresponding solemnity. Okay? It says in closing, every person to whom the use or any real estate within the state has been sold, given, limited, granted, released, or conveyed by deed, grant, or any other legal conveyance whatsoever, or that shall hereafter be granted by any deed or conveyance whatsoever, and his heirs or assignees to be held to be in full and ample possession of such real estate to all intents, construction, and purposes, as if such persons, his heirs or assignees, were possessed thereof by solemn lottery of season in possession, and the usage or custom to the contrary is notwithstanding. So if you're not going based upon 46:3-2, then you're in violation of the law. It's right here. Operation of law. The tenures, honors, manors, lands, tenements, or hereditaments, or estates of inheritance at the common law held either by the King of England or any other person or body of politics or corporate at any time before July 4th, 1776, should remain in free and common sockets. That is the concept of the crown. Why? Because the land is in fact allodial. That is the purpose of escheatment if the land is allodial, according to operation of law via legislative intent. Okay? All gifts, grants, or conveyances made prior to July 4th and after July 4th, 1776, wrong one. Straight legislation of the demise of the crown. Okay? The crown is alive and well. Reserved by a statute. This is statute in regards to the land being allodial all the way back to Queen of Victoria's Edward I, all the way back in the 15th century, 13th century. Those laws are still intact. Okay, all gifts, grants, conveyances made prior to and after July 4th, 1776 of an estate of an inheritance under the King of England, body, corporate, or person by a letter patent or under the great seal of the state. And we know New Jersey didn't get there from as a grant under the great seal of the state because they didn't have the King seal on it. Okay, the King seal is my seal. Okay, so every state, contrary to this enactment, has been forfeited because it remains allodial. I didn't say that. I'll just elevate a couple of states right here. Let's close out on it. All right here. They say, and modern usage, not ancient, not medieval, but the modern usage of escheatment signifies the falling of property to a sovereign for want of an owner. This category embraces not only property which has no owner, all right, but also property whose owner or whose owners or whereabout is unknown. This is talking about an heir. Under the common law of England, escheat came to be classified as another branch of the king's ordinary revenue. What was originally an incident of tenure is now an incident of sovereignty. The doctrine of escheat at the earliest common law, even now in modern operation of law, only acts only upon that which was the subject of the tenure, since it related to the reversionary or remandment right of the reverser of the lord to take for want of a tenant in chief. This is called a landlord, which was originally extended to include personal property, tangible and intangible, brothers and sisters. All right. The principle was that the right to take that which belonged to no one was appertaining to the crown as crown's jure regalia, under the crown's radical title. Crown steps in to take property which is vacant. Okay? Property described as vacant is called bona vacantia and is taken or assumed by the state, as I just showed you, as its own until the real owner or true owner does in fact show up. What owner is it? Property of this class falls under the statute we're reading, revised statute 4603-2 and 4603-6, being as the allodial. The crown, as a matter of right, is exercised of the sovereign power of the king, especially in regards to personal estates, which are allodial by law. We just read it. The king is last heir when there is no king. Did you hear that? The king is last heir when there is no king. That is fire for that ass. Okay? That's fire for that ass. So in lieu of that, Yeah, the crown. Let's stop here. Right? In each commonwealth or republic rim, the term the crown at its broadest means the government or polity known as the state, while the sovereign in all rims is the living embodiment of the state. The living embodiment of the state or symbolic personification of the crown. In the Bible, you call it incarnation. We call it personification. Embodiment, brothers and sisters. Each commonwealth means the embodiment of the next king based upon the conscious perception of the thoughts in reference to the personification of the king in lieu of the embodiment of the crown, which is a corporation soul, an individual office holder. The crown and the sovereign are conceptually divisible but legally indivisible. The office cannot exist without what? The office holder. What does this do? What does this do? What does this mean? This theory is the office cannot exist without the office holder. This theory is the basis of the immediate succession of the either a new British monarch de facto or a de jure monarch upon the death of his predecessor. While the body naturally may have passed, the body politics still lives on. Okay, Rex not what is it? Rex, not what is it called again? Rex Nunquam Moritur. Okay, very important. The term crown, the crown in right jurisdiction, his majesty the king in right of jurisdiction, and similar or all synonymous in the monarch's legal personality, and sometimes referred to simply as the relevant jurisdiction name. In countries using a system of government derived from Roman civil law, the state is the equivalent concept. However, the term the sovereign or monarch and the crown, though related, have different meanings. The crown includes both monarch and the government. Just like you've seen in 1702, which is indefinite, it means the same then, and it means the same now. Why? But the crown also represents the legal embodiment of the executive, legislative, and judicial governance, while the crown legal personality or personification or incarnation through incorporation is usually regarded as what? A corporation soul. It can at least for some purpose be described as a corporation aggregate, being de facto, headed by a de facto monarch. Okay? And what is the concept of the crown? The concept of the crown took form on the feudal system, which you see under the revised statute, though not used this way in all countries that has the system. In England, which we're talking about right now, according to the common law and according to the statutory law, which you read the same language, verbatim, all rights and privileges were ultimately bestowed by the ruler. What ruler? The King of England. Land, for instance, was granted by what? The king or the crown, but because the king personifies the crown, because the crown land is what? Intel. And I'm going to close on that. The crown to the Lord to exchange for feudal services, which is called free and common, so-called as you see in the statute. Never changed. The demise, the transfer, the conveyance, library season has now been done. In turn, granted the land to lesser lords. One exception is this was the common socket owners of the land held as socket held is subject only to what? The crown. When such land became ownerless, they are said to exceed, i.e., return direct ownership to the crown land, Bana, Baker, Tenia, under the royal prerogative. We just read that, brothers and sisters. Right? Let's read crown land in close. Crown land in close. If you only the king can give it to you, brothers and sisters. You can go to sleep if you want to. Majority of you are already asleep. Crown land, also known as royal domain, is a territorial area belonging to the monarch, who personifies, you hear that? Personification, incarnation, incorporation, who personifies the crown. It is equivalent of an intellestate and passes with the monarchy being acceptable from it. This is called the statutes of mortmain. Statutes or mortmain, a dead hand. Let's look at it. Statutes of mortmain. That's crazy. The algorithm. Statutes of mortmain. Statutes of mortmain were two enactments by Edward I. In 1290, Queen Pretorius passed in the reign of Edward I of England aimed at preserving the kingdom's revenue by preventing land from passing into the possession of the Roman Catholic Church. Possession of the property by a corporation such as the church was known as mortmain, meaning literally dead hand. In medieval England, feudal estates generated taxes for the king known as feudal instance, principally on the grant or inheritance of that estate. Okay? That statute is right here. Right here. Alienation of freehold, statute of Queen Pretorius Terranum. The statue is right here, alive and well, brothers and sisters. How many leaders can show you that? Only a true leader can show somebody something that is able to lead them. Okay, this is the this is the navigational tool to be able to navigate to wherever we need to navigate to, whether we're on land or sea. It's the law. Because God makes the law and the law makes the king. And without no law, there is no inheritance. So the law preserved the inheritance by what we call operation of law. Operation of law. Okay? Very important. So, honors to the 32 English Church of England. Honors to the 32 English Church of England. Honors to our king, which I personify in the present day as King Clifford Jefferson. Jefferson meaning Godfrey. Godfrey means peaceful territory. I am making sure that the demise, as established by the Crown Act of 1702, is a sure thing. Okay? How we know it? Our charter. Okay? Our charter. Right? Our charter, brothers and sisters, right here. The authentic charter. Let's read this. Right here. Statutory code, power and authority under the common law of England. Article 12. This is the law saving the rights under the charters granted by Great Britain, being Section 12 of an act to incorporate the trustees of religious societies, approved April 9th, 1875, saved from repeal. It's an act to incorporate, brothers and sisters. It is an act to incorporate trustees. All right, parts of me, let me just backtrack. It was an act to incorporate trustees of religious societies, approved April 1, whether they were de jure or de facto. There had not been a de jure trustee on behalf of the charters granted by Great Britain here in the state of New Jersey till I came upon the scene. There ain't no charter being given out by the de jure king here in North America until I came upon the scene. Why? Because there ain't no trustees already in place. And we know Martin versus Waddell says the only king is the only trustee is the king. All right? So it was an act to incorporate, personify, incarnate the trustee, whether I'm in office as the king as trustee, or if I'm not in office, my representative. All right, approved April 9th, 1875, saved from repeal. This act vested property held under charter of incorporations granted by Great Britain and corporations and created in place thereof. You hear that? So other corporations created in the place thereof of the original corporations granted by charter. We know corporate powers derive their authority from a sovereign grant. Okay, so being that we incorporated under 16:1-28, right, stated under the charge of Great Britain, to compel an act to incorporate trustees of the society for property held in corporation place thereof, then the only thing that I'm there obligated to do is fulfill that prophecy. Okay? Very important that we understand that. And with that, I think I'll close. Yeah, I'll close. So once again, thank you all for being here today at the Third Convention of England, amongst your king, the guider of the nation for the English people, as well as preserver of the nation for the English people, as a British patriarch. Okay? Please pass this information on to all those who need to be aware of what's coming down the pipe. All right? That clock will strike 12. Whether you're ready for it to strike or not, it will strike. With that, I'm going to greet you as I always greeted you, and that is in peace and love.